It's 12:02 on Tuesday, almost said February, March the 12th. The House Criminal Justice Subcommittee is now in session. Madam Clerk, please take the roll.
Representative Davis, Fritz, Gillespie, Hardaway, Howell, Halsey, Johnson, Lamberth, Moody, Russell, Towns, Chairman Doggett.
Present.
Chairman Doggett, you have a quorum.
Thank you, ma'am. Members, do we have any personal orders before we begin? Seeing none, we'll go to our neighborhood-friendly Sergeant of Arms, Mr. Tyler Muniz, for our weekly words of wisdom.
Good day, everyone. Today's words of wisdom are brought to you from a country legend, the man in black, Johnny Cash. My arms are too short to box with God. Y'all have a great day.
All right, members, we've got another lengthy calendar. We'll get rid of a few of them here. Item number 6, House Bill 2386 by Representative Gant, rolled 1 week. Item 38, House Bill 2611 by Representative Zachary, rolled 1 week. Item 40, House Bill 2495 by Representative Hurt, rolled 1 week. Item 43, House Bill 2667 by Representative Raper, rolled 1 week. Item 54, House Bill 1878 by Representative Freeman, rolled 1 week. And item 83, House Bill 2670 by Representative Farmer is off notice. Brings us to item number 1, House Bill 1614 by the Chairlady Hazelwood. You're recognized. You do have an amendment code 14447.
Motion.
Do you wish to proceed with that amendment?
I do.
All right, members, let's get that amendment adopted. All those in favor of adopting amendment code 14447, say aye.
Aye.
Those opposed, ayes prevail. You adopt. We're on House Bill 1614 as amended.
Thank you, Mr. Chairman. This bill is the Protect Tennessee Minors Act, and all it is doing is attempting to restrict children from explicit adult content. What we're doing with this bill is trying to match in the cyber world what we already do in the physical world. We don't allow our under 18s to go into adult entertainment establishments, and we don't allow them access to certain materials. Unfortunately, in the cyber world, it's much easier for them to access it. And this bill would just attempt to restrict, remove the exposure to pornography that's happening. It's mind-boggling, but a national survey said that 73% of teens under ages 13 to 17 had watched pornography. They self-admitted to that. 54% said they first watched it before the age of 13. So this is a real problem. It affects our children emotionally. It affects their ability downstream to form healthy relationships. It really is a form of sexual abuse, in my humble opinion. So again, the bill that you have before us today would restrict that by requiring these type sites to require, they would have to have age verification before somebody was able to access their site. We already in the General Assembly in 2017 joined with several other states in recognizing pornography as a public health crisis. We had a joint resolution in that regard. This is just the logical next step in dealing with that crisis. 7 other states have already passed similar legislation. I've worked very closely with a lot of constituent groups, with the legal community to bring this bill before you today. And I have to tell you that it first came to my attention from a constituent who brought me some sample legislation. He has small children who are getting into their teenage years and was very concerned about that. So the bill is, there are a number of parts to it, and I know that I have a time limit, but some of the things that I think will be important to the committee to know, it sets a requirement for individuals or commercial entities to publishing content that is harmful to minors. under this requirement, website owners have to implement a reasonable age verification method for access, and they have to anonymize that information. It's not that they're going to hold that over someone's head that they have accessed that site. That information will be anonymized. Violating it will be a Class C felony, so I know this does have a fiscal note. The bill does, websites that would be affected include websites that have 33 1/3% or more of their total content consists of content that we would deem harmful to minors. And there's a very explicit list in the bill of what sort of content that would be, what activities and body parts would be included in these restrictions. And it just simply says that the content that an average person applying contemporary community standards, taking the material with respect to minors of any age, they would find that to be sexually explicit and harmful or inappropriate for minors, and designed really just to appeal to prurient interests. There are no redeeming social, literary, or other values. So the website owners have to install commercially reasonable age verification processes. They would match a user's photo ID to some whatever a legal, a driver's license, whatever other kind of legal documentation might be appropriate. And as I mentioned earlier, the stored data wouldn't include any personally identified information. So I know there's some concerns about freedom of speech and that sort of thing. So, and again, as I mentioned, violators would be a Class C felony. I would mention that under the bill as written, the Department of Safety and the AG's office would be the enforcement arm. The Department of Safety came to me yesterday with some concerns, and I'll be working with them on an amendment to address their concerns should this get to full committee. With that, Mr. Chairman, I would stand ready for questions.
Well, thank you, ma'am. And for the explanation, we have Chairman Halsey on our list.
Thank you, Mr. Chairman. I'm for your bill, going to vote for your bill. I signed on your bill.
Thank you, sir.
I just, I wanted to know, the other side's going to press a First Amendment issue, and they're going to say it's not our responsibility, it's a parent's responsibility to keep their kid from watching this stuff on their phone. What's your answer to that? And I think there's some other states maybe that passed a similar bill and they've been enjoined by the courts. And what's your answer to that?
I mentioned earlier that I worked with legal, our legal department, other legal entities. There are some bills that have been, or some states that have had that enjoined. There are some other states that have not. And I feel that we have used that information here. We recognize what their arguments were, where there have been cases brought, and we've addressed those, I think, sufficiently in the bill that we will be able to defend this successfully in court.
Any other questions for the sponsor? Representative Hardaway.
Thank you, Chairman. And I'm probably the only one who hasn't signed on yet. Okay.
There's still time.
Yes, ma'am. And I plan to take advantage of that time. But having had friends, close friends, who have had this problem, I can tell you that it's much needed. The wonderful thing about the internet is it has access to the world. The worst thing about the internet is it has access to the world. And unlike when I was growing up, you're a lot younger than me, Madam Chair. So we had information that came in that was filtered, and you got the guidance from, and everything was put in context by your parents or another responsible adult. And the problem we have now is that information flows in no matter what, unfiltered, with no guidance from a mature parent, a mature caregiver or parent. And the streets and the internet end up raising and influencing our children more so than the parents or any other person, because they can spend more time on that internet, on that phone or PC or iPad than they do waking hours with us. So I thank you for this. It's long overdue, And thank you for having the vision and getting this done. Thank you.
Thank you. And I just reiterate what I said in the beginning. This bill would attempt to do in the cyber world what we already do in the physical world. It's just that technology has outstripped our regulatory oversight, and this is an attempt to bring that back in line. Again, we have seen, all of us are aware of the just exponential increase in mental health issues, particularly with our children. And I sincerely believe that this is one of the causes. And so anything that we can do to help control that, I appreciate your support in helping make that happen.
Any other questions, comments, concerns? Seeing none, we're now voting to send House Bill 1614 as amended to full criminal. All those in favor say aye. Aye. Those opposed? Ayes prevail. You move forward.
Thank you, Mr. Chairman. Committee.
Item number 2, House Bill 2538. Representative Cochran. You're recognized. There are 2 amendments.
Yes, sir, Mr. Chairman. If it's the will of committee, we'll go ahead and put those on if that's okay with you.
Both of them.
Yes, sir.
All right. First amendment we have is Amendment Code 15305. All right, you recognized on the amendment.
Thank you, Mr. Chairman. And this may be a question for legal. I don't know if it matters what order we put them on. I know that the drafting code you just mentioned just changes a subsection of the bill. Does it matter which order? Okay.
It does not. We'll go ahead and all those in favor of Amendment Code 15305 say aye. Those opposed? Ayes prevail. You adopt. We're on to Amendment number 2, Amendment Code 14483.
Yes, sir.
All right, you recognized on that one.
Thank you, Mr. Chairman. And so this makes the bill. And I want to tell you the initial amendment. So let's talk about this, what we've got before us first. This is introducing a charge of a threat of mass violence, which really does not exist in our code currently. It gives our DAs an additional tool. So essentially, if someone calls and threatens to shoot up a shopping mall, a public park, it could include a school, but any public area. If you're making the threat, right now there's not a whole lot the DA can do other than a misdemeanor charge. There's a charge of like a terroristic threat, but that's a very high threshold. And so this is just giving DAs an additional tool if someone's making an actual threat on a place, something to charge an assailant with. What the other amendment that we voted on is increasing that threshold. The original bill has if a person commits an offense who recklessly communicates a threat. We're this other amendment, and this was just simply an amendment that I brought. It increases that threshold to knowingly. We want to make sure that this law is capturing those folks that we are meaning to target, not just someone who makes an offhanded comment. With that, I'll yield to any questions.
All right, thank you. Are there any questions on the amendment? Seeing none, let's vote now on Amendment Code 14483. Those in favor say aye. Aye. Those opposed? Ayes prevail. You adopt. We're going to roll both amendments into one. And now we're on House Bill 2538 as amended. Questions for the sponsor? Seeing none, we're voting to send House Bill 2538 on the full criminal. Those in favor say aye. Aye. Those opposed? Ayes prevail. You move forward.
Thank you, Chairman and Committee.
Yes, sir. Item number 3, House Bill 1825 by Representative Farmer. Well, I'll tell you what, we're going to roll him. We'll roll 2 spaces. Without objection, we'll roll 2 spaces. Item number 4, House Bill 2761 by Representative Kiesling. We'll roll this to the Hill. Item number 5, House Bill 2790. All right, we'll roll this to spot number 39. And that would bring us back to item number 3. But we will roll it nowhere. Because he's coming. You're recognized. Representative Farmer, there are 2 amendments. I'll give you a second to get up there.
Thank you, Mr. Chair, committee members. Apologize about that. You know, this time of year is kind of like it's March Madness here at the State House and in NCAA as well. Yeah, if we could move with Amendment 15567, that'd be great.
All right, Amendment Code 15567. All right, you're recognized on the amendment.
Thank you. And what this does, members, this amendment does make the bill here. What this bill does is adjusts our limits that we can purchase prescriptions or non-prescriptions, I guess, like Sudafed and things for yearly allergies and such. We're going to increase that limit a bit to allow for folks to be able to purchase more there. For example, right now, the way the limit's set, you can come in and you can buy a box and a half. So there's no way to really buy a box and a half. Just lined up where you could buy basically 2 boxes of Sudafed a month and raise it from 5 grams to 7 a month, and the yearly amount from 25 to about 42. So that's what this does. Be happy to answer your questions.
All right, any questions on the amendment? Seeing none, we're voting to adopt Amendment Code 15567. Those in favor say aye. Aye. Those opposed? The ayes prevail. We're back on 1825 as amended. We do have some that have requested to testify, but they have said, never mind. So any questions for our sponsor? Yes, sir. Leader Lambert.
Just to say, Chairman, you and I have been down here more years than we like to admit sometimes, and this was a massive issue that we as the legislature worked on hard to curtail meth labs in the state. We worked with law enforcement and everyone else, TBI, and I really appreciate you working with all of them because I know we're trying to kind of ease back that a little bit to help those that suffer from allergies in this state without cracking this open so that we start seeing meth labs again. So I appreciate all your hard work. I know there's lots of bills on the calendar today, but this one took a lot of time, and I appreciate you working with law enforcement to get to a point. And I know this is something you'll watch very carefully over the next few years. We start seeing meth labs crop back up, we can always trim it back down again. So just thank you.
And thank you, Leader Lambert there. Yeah, when this bill started out, it was unlimited yearly amount. We worked our way down. We worked with other stakeholders here, our sheriffs and other folks. So, and this was a big deal then. And there were a lot of pop-up little shake and bake meth labs around the state. I guess this has been 10, almost 12 years ago. I guess we passed this. So things have substantially decreased almost to nothing now. But if things were to change, we can certainly come back and we can put the adjustments back on. So for right now, if we could allow folks to get the medicine they need when they need it, it'd be great. And I appreciate the approval.
Any other questions for the sponsor? Seeing none, we're voting to send House Bill 1825 to full criminal as amended. All those in favor say aye. Aye. Those opposed? The ayes prevail. You move forward.
Thank you.
Members, let's roll down to item number 36. House Bill 2429 by Representative Farmer. You're recognized.
Thank you, Mr. Chair. Members, remember what this does. This is something that would allow for folks who are or would be convicted of a DUI first offense to be sentenced to an alternative facility. This is already in statute, in code, allow for the sheriff to allow a first offense DUI offender to serve their 48 hours in an alternative facility that's licensed by the Department of Health. This would change the decision-making from the sheriff to the general sessions judge, which is a good policy because the judges are the ones that see and hear from these defendants. They work with the local assistant district attorneys and district attorneys that are looking to maybe offer plea agreements or really boots on the ground and understand what's going on much more than really the sheriff does in these types of situations. So it kind of leaves that, it does leave the discretion with the local judges. So with that said, members, I'd just ask for approval.
Any questions for our sponsor? Seeing none, we're voting to send House Bill 2429 to full criminal. All those in favor say aye. Aye. Those opposed? The ayes prevail. You move forward.
Thank you, members. Mr. Chair.
Item number 6 was rolled a week. Item number 7, House Bill 2848. Representative Wright. He is not, there he is. No amendments. You're recognized.
Thank you, Mr. Chairman, committee. I would like to say I would like to be brief. For just a moment, let me look at in Tennessee Code at 3914-803 and read just a sentence or two. A person without consent of the owner exercising control over an animal facility, an animal from an animal facility, or other property from an animal facility with the intent to deprive the owner commits an offense. I said animal 3 or 4 times. I wish to propose that in state code that and I don't know how to refer to this, that bees be referred to as animals. In fact, they be added as to include bees in a structure or equipment used to keep, handle, house, exhibit, breed, or offer for sale bees without the consent of the owner or without the intent or with that intent to deprive the owner of their bees, structure, or equipment. So let me pause for a second. I'm not going to say be brief again. Let me stand for questions. Okay, while you're formulating a question, thank you, Mr. Chairman.
Well, I just wanted to give you a little bit of good news.
I can stand good news.
In the chapter, in the part that you're looking to address, it already defines bee as an animal.
Can't beat a deal like that.
I know it.
And excuse me for taking up your time. I submitted my request and what I got back was what I've just read.
Well, very good. Any questions for the sponsor? Representative Hardaway, be brief.
Thank you. And Mr. Chair, I'm not sure, did you say BS?
Come again?
It means okay.
All right, I'm not going to participate. I refuse. I know how this is going to look later on video. So I want to, I believe, I want to thank you for the bill because one of the problems that we have is the impact on the environment because of the loss of bees and their ability to pollinate and keep balance in our environment. So anything that we can do to protect them, keep them with people who know what they're doing, beekeepers that know what they're doing and are able to care for them and keeping them off the black market makes sense to me. I consider it to be an environmentally friendly bill. So be safe, sir.
All right. Any other questions for the sponsor? I don't see any. All right. We're voting to send House Bill 2848 to full criminal. All those in favor say aye. Those opposed? The ayes prevail. You move forward.
Thank you, Mr. Chairman, committee.
Mr. Chair,
Yes, sir.
could I be out of order for a minute?
Yes, sir.
I've got a lot of fine looking folks in the audience. They're here with Tennessee for All, and they work on issues which are about equity and equality and justice. And they're here to watch us, in essence, take the first step in delivering justice for Tennesseans. So if y'all would give all these fine looking folk who have on, some of whom have on these fine looking t-shirts, which I'm gonna beg one for later, if you would just let them know that they're welcome. And we appreciate you taking the time, spending your own money to come up here on the Hill to look after the people's business. So welcome.
All right, item number 8, House Bill 1872 by Representative Fritz. You are recognized. There is an amendment code 14625. You're recognized on the amendment.
Thank you, Mr. Chairman and committee. This legislation, as amended, does a few things. It permits a court to add enhancement factors of up to imprisonment for life without the possibility of parole for conviction of an illegal alien under the following circumstances: commission of a violent crime or use or display of a deadly weapon in commission of that crime. It requires that these arrests and subsequent convictions must be reported to the Tennessee Department of Safety and Homeland Security. It permits the court to add enhancement factors of up to life in prison with no possibility of parole for the conviction of an adult who commits an act of violence on a school property in Tennessee. And it adds, finally, consideration of legal residency as the magistrate considers bond. Why is this legislation needed? With the Congressional Committee on Homeland Security reporting that U.S. Customs and Border Patrol had 6.2 million encounters with illegal aliens in FY 2023, and that during that time, another 1.7 million illegal aliens evaded U.S. Customs and Border Patrol and entered the United States. With Tennessee being within a day's drive of 60% of the U.S. population and being bordered by 8 other states and having 7 interstates running through it, the odds of these illegals passing through our state is high. Our criminal justice system routinely enhances penalties when one criminal act is committed at the same time as another, such as killing someone during a bank robbery or an armed robbery. Illegal aliens, by entering the country, have committed a crime. If they commit another crime, especially a violent crime, those consequences should be enhanced. Our schools should be places of learning. We should have consequences in place to make it clear to those who consider offending such that those areas are maintained in a peaceful, solid learning environment. I think it's absolutely important for us. It's hard to combat a problem if you don't know what the scope of the problem is and what the problem entails. For us to truly understand the impact on our state, especially those that commit violent crimes, we must begin to collect data, and we will do that with this bill. By making violent crimes committed on school property subject to sentence enhancements, perhaps those who want to commit violence will think twice before they endanger our children in this great state. With that, Mr. Chairman, I'll take any questions.
Questions on the amendment, Representative Johnson.
Thank you, Mr. Chairman. In multiple consultations with attorneys, what I've discovered is that this bill, based on sexual battery, if you were to pants a referee on school property, that would lend to the potential of a life sentence without parole for an undocumented individual. Is that correct?
Thank you, Mr. Chairman. I'm not sure I know the answer to that question, Representative. I'm not sure where you did your research there, but I'm not certain about the answer to that.
Okay.
I would add one other quick thing, if I might, Mr. Chairman. And I understand where the representative's going with this, and I respect you, and I thank you for that. These are serious things that we're discussing, and perhaps to make it something political rather than protect our children by enacting this bill is a little bit appalling to me.
I appreciate that, only it's not political. It's showing an example of where someone may get no consequences and another individual could get life in prison for the same event. And I think that's very concerning, not to mention the constitutionality is suspect here as well. So it's not political to say that. It's an actuality, a thing that could happen and could happen to someone who committed that act. And we need to take that seriously as well. I know this is serious.
Leader Lamberth.
Move previous question.
Question has been called on the amendment. Any objection? Seeing none. All right. Then we're voting on previous question on the amendment. Those in favor of previous question, say aye.
Aye.
Those opposed? Previous question prevails.
Thank you, Mr. Chairman, committee.
Whoa, time out. We're on the amendment. We're voting to attach Amendment Code 14625 on the House Bill 1872. Those in favor say aye. Aye. Those opposed? No. The ayes prevail. If you wish to be recorded as a no, please see the clerk. We're on 1872 as amended. Any questions on the bill as amended? Representative Hardaway, do you have a question or was you notifying the clerk?
Both, sir.
All right, go ahead. You're recognized.
Would ask the sponsor to give us the overall for the bill as amended.
Thank you, Mr. Chairman. Thank you for that. The bill as amended very basically addresses some of the problems that we have in our state. Crimes committed, violent crimes, crimes with deadly weapons committed in our state, not only by those who are illegally in the United States, but those that have been committed in our institutions of learning across the state. And so it basically does four things. The conviction is for a commission of a violent crime and the defendant was an illegal alien at the time of the offense was committed, or the conviction involves the use or display of a deadly weapon and the defendant was an illegal alien at the time the offense was committed, or the conviction is for the commission of a violent crime committed by an adult and the offense occurred on the property of a school. And in those three circumstances would result in a possible enhancement to life in prison.
And you said possible enhancement. So it's still prosecutorial discretion here?
Thank you, Mr. Chairman, and thank you for that question. I'll just read from what the code said, the proposed code says. Notwithstanding another law to the contrary, and in addition to the enhancement factors described in 4035-114, a court may enhance the statutory penalty up to imprisonment for life without the possibility of parole.
All right, that gives me my answer. Where you and I would differ is taking the stance that being an illegal immigrant or undocumented immigrant would be an appropriate item for enhancement. I think we have what we need in place in terms of federal law and federal executive actions to address that. We just need to put some money behind it and make it a reality. So I'm not sure how this fits in to the overall scheme of things in addressing the issues that we have with our borders. But thank you for engaging, sir.
Mayor Lamberth.
Thank you, Mr. Chairman, and thank you for bringing the bill. I mean, in most other aspects of the criminal code, as everyone on this committee knows, if you are out on bond for a crime and commit another crime and are convicted of both, then the penalty is enhanced. If you have a lengthy criminal history and have committed multiple other crimes, then the penalty is enhanced. If you are a repeat criminal, then the penalties get worse. Look, we can dance around the language all we want. We can dress it up by saying undocumented immigrant or whatever else. These folks are illegally in the country. They should not be. And every day they're illegally here, they are committing a federal crime. Now, if the federal government wants to get off their keister and actually make the immigration system work, then it saves all of us a whole lot of trouble. But while these folks are here, if they are committing crimes and they've not gone through the lawful process to be here legally, then that is an enhancement under this bill for committing these violent crimes. I think that's absolutely appropriate, just like with any other crime, that if you were committing one crime and committed another one, then it enhances that crime. So it to me is a very appropriate bill. I appreciate you bringing it. I hope it will deter folks that while they are wading through an absolutely broken immigration process, that the federal government needs to fix. That's for them to do so, both executive branch, legislative branch, all of them. But while they are waiting through that, and we have folks in our midst that are here illegally, I just don't want them to commit crimes beyond the federal crimes they are already committing. And so I appreciate the bill, certainly support it, and thank you for bringing it.
Thank you, Mr. Chairman, and thank you for your remarks. This bill doesn't address anyone other than those who have come here with criminal intent. The crimes that we have listed in current code that are violent crimes are egregious crimes. And we should establish clearly and for all to see that we Tennesseans will not tolerate an invader on this nation who has come here and decided to commit those violent crimes, nor arm themselves with a deadly weapon to do harm to Tennesseans. And I feel bound by my oath to protect the folks of Tennessee. And that's what I'm trying to do. So thank you.
Representative Hardaway.
Thank you, Chairman. And Leader Lambert just brought another question to mind for me. Just a what if? What if someone that's holding a visa or a green card and it's expired and of course, anyone that's committing a violent crime needs to be dealt with and dealt with harshly. But would they also qualify for the enhancements?
Oh, thank you, Mr. Chairman. I would offer, Representative, thank you for that question. And again, focus on the violent crime or the commission of a crime with those deadly weapons. If that person is not legally in status in the United States, I would say yes.
And thank you for the answer. And I guess if we really, we were talking about the federal government doing this job, if we, and I'm including all of us with that royal we, were doing our job and we had enough deterrents in place, including the one that you're offering as an additional charge. If we had that deterrent in place for the overwhelming percentage of the population, which is Americans who are here legally, born here, or those who have come in legally, but overwhelmingly those of us who were born here. If we had enough deterrents in place, then we would make a big dent in violent crime, period. So I'm not sure about how you get where you are with the enhancement, but we agree that violent crime needs to be deterred. And I look forward to working with you on other bills in the future on making sure that we maximize the deterrent factor for those who just can't live peacefully in society. Thank you.
Thank you, Representative Hardaway.
Representative Towns.
Mr. Chairman, thank you. Obviously, as we would agree, everybody wants to do something about crime. We need to do something. We totally don't know what to do. So we're trying different things. What I'd like to know about the data, if we collect this data, do we plan to collect the data so we can see how effective or not that we're being? Will this bill allow for us to collect the data? We need to collect the data so we'll know what we're doing. So if we have to come back to tweak, we have something to go on. If we don't, shooting in the dark again. Mr. Chairman.
Yes, sir.
Thank you, Mr. Chairman. Thank you for the question. Yes, and part of the idea, Representative, is to collect data so that we can become more effective with this. And I will go back to the school portion of this that's easy to overlook. We just suffered here last year in Nashville a horrendous event.
Yeah.
And we should be putting up an absolute message to those evil people that wish to do harm to our children, that we in Tennessee will not tolerate it. And that there's a possibility if you start down that path in Tennessee that you will not see the light of day.
Well, Mr. Chairman, I'm hopeful that whatever bill any of the members bring that will help us to do just that, I'm sure there are others that we can accomplish it, but I'd love to see it in writing. I mean, I'd love to see what the data collected so we'll know exactly if we're doing the right thing or not. And we want the same things for the most part that I see as it relates to our children and our communities, not just in Tennessee. We want it countrywide. We want safety. We deserve safety. Human beings deserve a right to live, free of fear, terrorism, and all this craziness. So we'll see. Mr. Chairman, thank you.
Thank you. Any other questions for the sponsor? Seeing none, we're voting to send House Bill 1872 on the full criminal. All those in favor say aye.
Aye.
Those opposed? The ayes prevail. If you wish to be recorded as
Thank you,
no,
Chairman,
please say the
committee.
clerk. You move forward. Item number 9, House Bill 1911. Representative Bolso. You are recognized.
Thank you, Mr. Chairman. Good afternoon, members of the committee. This is a bill that amends our law on unlawful photography. Unlawful photography is already a crime, but under current law, if one uses a phone camera or any other device to take a photograph of someone's intimate area for the purposes of sexual gratification or arousal, that's only a Class A misdemeanor. And this bill is actually an idea that was generated from several young ladies in my district who were victimized by unlawful photography. And what the bill does is simply to increase the penalty for this conduct from a Class A misdemeanor to a Class E felony. And then it increases Class E felony to Class D felony if there are aggravating factors, such as distribution of the unconsented to images that were taken, or the involvement of a child who's less than 13 years old. And with that, Mr. Chairman, I'm ready for questions.
Any questions for the sponsor, Representative Johnson?
Thank you, Mr. Chairman. I guess one question that's been brought to me, and just want to clarify because I appreciate what you're doing, is that this could be used parent against parent in like a divorce situation or something like that. Because isn't there something within the bill that says if someone is embarrassed by a photo? I mean, you think about photos of kids in bathtubs, just things like that. So I'm curious, are there any protections in there if we're in that type of a situation where, somebody decides that, oh, you took this embarrassing photo of our child, that type of thing?
Sure. Thank you, Mr. Chairman, and thank you, Representative Johnson, for the question. I mean, the short answer is yes. When you look at the statute, which is 39-13-605-1A, it requires not just that a person be embarrassed or offended by the photograph, but rather that it was taken for purposes of sexual arousal or gratification without the person's consent. So that's the type of conduct that prior General Assemblies have chosen to criminalize. And this bill doesn't really address whether or not conduct should or should not be made criminal. It just addresses the penalty available in the event that the conduct occurs. So to whatever extent there was a question about parent against parent, that question would still remain. This bill really does not address that type of an underlying issue. It just addresses the level of penalty.
Yes, ma'am.
And is this is there any judicial, is this a may or a shall? Does it allow the judge to make that determination on whether that would be considered a felony or not based on the knowledge?
Thank you, Mr. Chairman. Yes and no. With regard to the commission of the crime, no. If in fact the proof shows that the conduct was committed, then it is a crime. But one of the portions of the statute deals with registration on the sexual violators registry, and there, under current law, a judge does have discretion in certain circumstances about whether to put someone on the sexual victim violator registry.
Thank you.
Any other questions? Representative Towns.
Representative, on this registry, they're there permanently. Is this the bill that deals with keeping them there permanently if they don't violate after a certain amount of time?
Thank you, Mr. Chairman. No, this is not that bill.
Okay. So, but does it keep them there permanently?
It, correct. This would only, if the conduct were proven, place the convicted defendant on the sexual offender registry. How long the person stays there would be governed by Title 40, which goes through the different offenses that puts one on the sexual offender registry.
Thank you, Mr. Chairman.
Thank you. Any other questions? Seeing none, we're voting to send House Bill 1911 on the full criminal. All those in favor say aye.
Aye.
Those opposed? Ayes prevail. You move forward. Item number 10, House Bill 2546 by Representative Bolso. You're recognized.
Thank you, Mr. Chairman. This is a bill that tweaks the definition of harassment in Title 39. It actually came to me from Senator Gardenhire, who had a judge in his district in Hamilton County raise the issue. When you look at the definition of harassment currently in Title 39, it focuses on the mental state of the victim, not on the mental state of the accused. Under current law, harassment is defined as repeated unwanted contact with a person that would cause a reasonable person to suffer mental or emotional distress. This amendment tweaks the definition so that it is instead focused on the mental state of the defendant, which is where it should be for purposes of criminal law. If passed, this bill would define harassment as unwanted, repeated, unconsented contact with a person in reckless disregard of whether it would create mental or emotional distress. And reckless disregard is a concept in the law that requires one first to be aware of the risk and then act with a conscious indifference or disregard of the risk. So this is a bill that's already passed passed the Senate unanimously on their consent calendar, and I'm presenting it here today to this committee.
Very good. Any questions for the sponsor? Seeing none, we're voting to send House Bill 2546 on the full criminal. All those in favor say aye. Those opposed? Ayes prevail. You move forward. Which
Thank you, committee.
record as a
Thank you,
no.
Mr.
See the
Chairman.
clerk. Item 11, House Bill 2078 by Representative Ritchie. You're recognized. There are two amendments here. You wish to proceed with both, one or none?
Thank you, Mr. Chairman. I'd like to proceed with Amendment Drafting Code 15062.
All right. You're recognized on 15062.
Thank you, Chairman and Committee. House Bill 2078, pursuant to Tennessee Code 3917-114A, it is an offense currently for any person for the purpose of commercial advantage or private financial gain to transport or cause to be transported into the state an individual who the person knows or should have known has illegally entered or remained in the United States, as determined by the Bureau of Immigration Custom Enforcement of the United States Department of Homeland Security. What this legislation does is it will end up putting three exceptions from chatting with the Department of Safety. It will exempt DCS so that they're not included under this. It'll exempt law enforcement who are in the act of their professional ability. And then it also exempts the Department of Corrections. So DCS, law enforcement, and Department of Corrections. What it also does is under the current TCA code, it will take it and remove common carriers so that they do not have the immunity anymore. And then it increases the fine from $1,000 to $5,000 per individual. And with that, I stand by for any questions.
All right. Any questions on the amendment? Representative Johnson.
Okay, that last part, I guess, is where my question is. I'm thinking of some buses that were bringing people who had been approved to go to certain states across the country. They had stops in Knoxville, so that's how I'm aware on different buses. And we're talking about just public, buses. But they were being transported by these, like Greyhound or whatever organization it was. I don't know if the drivers were aware of this or not, but how is it if you can't find, how are they supposed to get to the designated states where they're headed, where they're typically it's refugees that are going to meet with family that have gone through the process and been approved to be here. They just have to check in monthly. So how are you able to do that without, with knowledge necessarily, or how is someone supposed to get to their destination if it's difficult to find transportation?
Thank you, Mr. Chairman. And as the current law, this isn't changing the current law. The current law states that knows or should have known has illegally entered or remained in the United States. This isn't changing what's current law. It's just expanding upon that common carriers would not have that immunity. My advice to those common carriers is go around Tennessee.
Wow. Thank you, Mr. Chairman.
Any other questions on the amendment? Seeing none, we're voting to attach amendment code 15062 on the House Bill 2078. Those in favor say aye. Aye. Those opposed? The ayes prevail. You adopt on House Bill 2078 as amended. We do have someone here for testimony, so without objection, we'll go out of session. Hear from Ashley Warbington. Please forgive me if I said your name wrong, but if you will, push the little button on there and it'll light up red. If you'll introduce yourself for the record, you will have 3 minutes for comments.
Thank you. My name is Ashley Warbington, and I sit before you today, not just as a concerned citizen, but as a mother and a proud native Tennessean. I urge you to consider the profound human impact and economic implications of HB 2078, a bill that threatens to tear apart families like mine and jeopardize the prosperity of our state. My son, Marco, who sits behind me today, is 7 years old and Mexican American. His father, Alejandro, has been an integral part of Nashville's fabric for 2 decades. Contributing not only as a hardworking taxpayer, but also as a dedicated business owner in the construction industry. Yet despite our contributions and our deep roots in this state, the passage of this bill looms over us like a dark cloud, threatening to shatter the stability and unity of our family. Alejandro is currently in the process of obtaining lawful permanent residence, yet he is not safe under this bill. This bill fails to address the plight of vulnerable individuals, including those with temporary protected status and those seeking refuge, who want nothing more than safety and opportunity. By denying them the chance to build stable lives for themselves and their families, this bill further compounds their suffering and undermines our shared values of compassion and humanity. HB 2078 is not just a piece of legislation. It is a dagger aimed at the heart of families across Tennessee. By criminalizing the transportation of undocumented immigrants, this bill seeks to sow fear and division in our communities. But behind every statistic lies a story of resilience, determination, and unwavering commitment to building better lives. In 2018, undocumented immigrants paid $85.9 million in state and local taxes in Tennessee. Immigrant entrepreneurs generated hundreds of millions of dollars in business revenue. But these are not just numbers on a page. They represent the sweat, the sacrifice, and the dreams of hardworking individuals striving to make a better future for themselves and their families. This bill threatens to extinguish those dreams and upend countless lives. It not only jeopardizes the unities of families like mine, but it also poses grave economic risk to our state. Similar bills in other states have led to labor shortages, crippled industries, and inflicted untold harm on local economies. In Florida, a similar bill precipitated a crisis in the agricultural sector. The consequences of such legislation are not confined to immigrant communities. They reverberate throughout our entire economy. We cannot afford to chart a similar course here in Tennessee. The United States was built on the back of immigrants who came to this land in search of freedom, opportunity, and a better life for themselves and their descendants. There was no ICE official awaiting refugees and dream seekers on Ellis Island. There was only a beacon of hope and a promise of a brighter tomorrow. This bill threatens to betray that promise and tarnish the very foundation upon which this great nation was built. I implore you to consider the human toll and economic consequences of this bill. Let us not succumb to fear and division, but instead let us stand together in solidarity with families like mine and uphold the values that define us as Tennesseans: compassion, fairness, and opportunity for all. Thank you.
All right, thank you. Any questions for our guest? Representative Johnson.
So you said your husband has a construction business?
He does. He owns a very successful construction business.
How long has he had that?
Over
business?
15 years.
Okay. Is that in Nashville?
In Nashville, yes.
Thank you.
Any other questions for our guest? Chairman Halsey.
Thank you. Could I just say Miss Ashley, is that all right?
You sure can.
Thank you for being here. I don't see how this would affect your family. This bill deals with the transporting into this state for certain purposes. I don't see how that affects yours.
Thank you for the question. It would affect, it affects me directly. I cannot go on a vacation outside of the state of Tennessee as a family. My son attends a school that's 56% Latino. All those families will also be affected, and we will be unable to take class field trips outside of the state. And respectfully, there are multiple bills coming through committee that would compound this, that would also lead to deportation of individuals that are stopped. Like if we were stopped crossing state lines, there are other laws currently making their way through that would just work in conjunction with this bill, which would lead to deportations.
Any other questions? Seeing none, we're going to go back into session. Thank you for being with us today. All right, we're back in session. I have Representative Gillespie with a question.
Thank you, Mr. Chairman. And sponsor, we talked about this and some of my concerns privately. I just wanted to make sure I understand what this bill does. Would this say a Delta Airlines pilot, the captain of the plane flying from LAX to Memphis, would this require that captain to verify on their own accord that no one on that plane is here in the country illegally? And if they were and he did not do that, they would be personally fined? Is that correct?
So in the legislation, it says knowingly or recklessly. So if the pilot knowingly transported them, then the pilot could be fined, correct?
All right, thank you.
Representative Towns.
Mr. Representative, the bill itself is not dealing with, or is it dealing with people that are coming into the country illegally, you state? It's dealing also with people that are already in the country that may be utilizing a vehicle to do everyday life activity as well?
So thank you, Chairman. So currently under TCA 3917-114, this is already the law. All this is doing is removing the immunity for common carriers, and then it's excluding those three categories, and then it's increasing the fine from 1,000 to 5,000. So it's not doing anything as far as for how it's changing from one state to the other. That's already in law currently.
Okay, help me delineate those vehicles that we may determine as common carriers. I'm sure a bus would be. What else would be designated as a common carrier in your opinion?
So common carriers could end up being the railway, Amtrak, United Airlines, Delta Airlines, Greyhound, any commercial carrier would be a common carrier.
Mr. Chairman, thank you again. Now, if a person got on a Greyhound bus going from point A to point B, how would the bus driver know what's going on?
Correct. And that's why inside of the language it says knowingly or recklessly.
So it has to be proven that that bus driver, excuse me, who's working for Continental, Greyhound, or whomever, they knew.
Correct.
Okay. And or recklessly. Okay. All right, Mr. Chairman, thank you.
Yes, sir. Thank you. Any other questions? Seeing none. Voting to send House Bill 2078 as amended to full criminal. All those in favor say aye.
Aye.
Those opposed?
No.
The ayes prevail. If you
Thank
wish
you,
to be
Chairman and
recorded
committee.
as a no, please see the clerk. Item number 12, House Bill 2288. Representative Hale.
Second.
You're recognized.
Thank you, Committee and Chair. House Bill 2288 there's something that we say many times that we want Tennessee to be the best place to work, live, and raise a family, and this is a bill that helps to do that, to make Tennessee safer. House Bill 2288 expands the mandatory minimum sentence for the employment of a firearm or antique firearm to include the commission, attempt, or flight escape from the commission or attempt of an offense other than a dangerous felony. Currently, the offense of employing a firearm during the commission of a dangerous felony is a Class C felony, punishable by mandatory minimum sentence of 6 years or 10 years for those with a prior felony offense. This legislation would also include crimes other than a dangerous felony, which would be Class D felony, punishable by a mandatory minimum of 5 years sentence. With that, I stand for question.
All right, any questions for the sponsor? Representative Johnson.
So one of the concerns that's been brought to me by attorneys is that, say, someone was being trafficked, they were participating in this crime, but not, because basically that they had to. So say that it was a robbery and the gun was in the car. The gun was not used inside for the robbery or burglary or whatever it was, but the gun was in the car. This is going to get that enhancement even though the gun was not used in the actual burglary, according to attorneys. And so I was wondering if there was any way we could remedy that, if that is the case. But I've talked to multiple folks who say that is the case.
What this bill is doing, it's tough on crime to make Tennessee safer. It helps to ensure that dangerous people are going to be kept from further harming others.
Yeah, and again, I feel like there are going to be those that did not use a weapon in the crime that they committed, but it was within, it was in the car or something like that. Several situations were pointed out to me. They're going to get people caught in this enhancement when the firearm or whatever was not actually used in the crime.
This would be if they employ the firearm.
According to the attorneys, it doesn't matter, according to the language of the bill.
I can get legal services to
That'd be awesome.
expand on that if you'd like. We'll go out of session, hear from legal services.
Michelle Fogarty, Office of Legal Services. The language of the bill says it is an offense to employ a firearm, not just to possess it. There's other language regarding dangerous offenses, distinguishing between possessing and employing. But for the circumstances of this bill, for an offense other than a dangerous felony, they have to employ the firearm.
Okay, so they absolutely could not have the gun in the car like I was talking about or anything like that.
That's a fact question, but the language in the bill is employ as opposed to possess, which is in other parts of the statute regarding dangerous felonies.
Okay, but you couldn't tell me for sure that would be ruled out.
I can't speculate on different facts, circumstances.
Thank you. Appreciate the information.
Any other questions for legal services? Seeing none, we'll go back into session. Any other questions for the sponsor? Seeing none, we're voting to send House Bill 2288 on the full criminal. All those in favor say aye.
Aye.
Those opposed? Ayes prevail. You move forward.
Thank you, Committee and Chair.
Item 13, House Bill 2814 by Representative Gillespie. You're recognized.
Thank you, Mr. Chairman and committee. This has unfortunately become one of my little projects here in the House. A couple years ago, I had a bill that increased the penalty of drag racing or organized street racing from a Class B misdemeanor to a Class A. Unfortunately, this is an ongoing problem that's not going away. People are dying both in my area and across the state and country. And what this legislation seeks to do is to raise the penalty for organized street racing from a Class A misdemeanor to a Class E felony. And with that, I welcome any questions.
All right, Chairman Halsey.
Thank you. What are they dying from? Are they wrecking or what's happening?
Thank you, Mr. Chair. And Chair, so unfortunately, it's all the above. There are people that are dying that are actually conducting this illegal behavior, but then there are also innocent bystanders that unfortunately are just at the wrong place at the wrong time. And I understand that that can happen on any roadway at any time, but this is illicit behavior and we have to do something about it.
Representative Johnson.
Thank you, Mr. Chair. If other people are injured or dying, there are other crimes that would be, that they would be charged with already. So enhancing this is, it's not preventing them from being charged with these other crimes of hurting anyone or innocent bystanders or any of those things. So I don't understand why you're going to give an enhancement for something for folks who are already going to be charged with the other crimes that they committed if that's what they did.
Thank you, Mr. Chair. This would be a deterrent. I would say that there are circumstances out there where, yes, someone has been charged with vehicular homicide, but there have been other cases, including a very unfortunate situation that happened about 2 years ago outside of Nashville, where those other charges are not happening. So what this seeks to do is to say, we as a state of Tennessee do not condone this behavior. Enough is enough. And I hope that those people that want to race on streets in my community will instead go to, say, a racetrack or file a permit or do many other things that they can to get the same kick or excitement or adrenaline rush without endangering people just going to the grocery store.
I guess and when I'm listening to this, it's already a crime. There are already other crimes to charge people with if they harm people. And we have not seen where enhanced punishment ever has been a deterrent to committing the crime. You talk about this thrill and this adrenaline rush. That's true. I don't think an extra penalty is going to make that difference. I think there are other ways to deal with this, but enhanced sentences have not proven to be a deterrent. And
Okay. Any other questions for the sponsor, Representative Towns?
Chairman, thank you. I want to go back to Chairman Halsey asked the question about the death, and obviously that would be something significant that we should look at if that be the case. The question of it is, Mr. Representative, do we have any statistical data that shows what kind of volume we're looking at? Now, notwithstanding the fact that I'm on the road and I see some of these guys, they scare you to death. I mean, they run up behind you doing 110, 20 miles an hour is absolutely frightening. And I know some people have had some close calls, but I'd like to know what kind of statistical data you've gotten that gives us some number and bear some numbers out of what it is that we're looking at that's killing people. What are the statistics, Mr. Representative?
Thank you so much, Mr. Chairman and Representative. I do not have a number of how many deaths have occurred specifically to drag racing as opposed to other traffic fatalities, but I will say it's probably more than you and I both realize. And I would also say that the reason some of these numbers for the the prosecution is low, I believe last year or year before last, the prosecution rate was almost 0 in Shelby County, but the arrest rate was over 100 incidences, is because both the DAs and law enforcement have told me over and over again that the way that they prioritize different offenses, that unfortunately drag racing combined with reckless driving is just not as high of a priority as it should be, which again is what I'm trying to address here.
Mr. Chairman, I'd love to see more data. We need the data so we'll know what we're doing now. As I stated, this is a problem on the highway. I mean, any of you have been on the highway anywhere in Tennessee, you see this stuff. I don't know whether it's drag race or not, Mr. Representative. Whether drag racing, they're speeding like a bat out of hell. I don't know, but it scares you. I know that when people come behind you like that. I would think the drag racing would be 2 or 3 guys running up down the street trying to see who has the fastest car or who has the best Hemi or what have you. But still, the data, we need some data at some point to see how effective we are or not being. Now, I'm gonna move on to another question. That there's a misdemeanor on the books. And if we have the misdemeanor on the books, are we prosecuting at the misdemeanor level again to see what kind of problem it is? It's frightening as heck, but what kind of problem it is? If we have data at the misdemeanor level, it will give us some idea of how much activity it is. I mean, not just Shelby County, statewide. If we have it, we have it. If we don't, we need to get more data. We need to really get more data, I would think. So have you looked into the misdemeanors and whether or not, what level we're prosecuting at the misdemeanor level?
Thank you, Mr. Chairman. I do not have that data statewide. I do know that we can go back and I will get you what the MPD and the Shelby County Sheriff's Office has presented to both our local legislative bodies on this issue. I can also refer to you to our DA who can really go into a lot of detail on as to why these cases are not being prosecuted. There are both reasons that I agree with and disagree with, but by enhancing this does bring it to a higher level of attention. And to comment on your earlier statement, drag racing is hard to prove in itself because it's 2 or more people racing in a predetermined location at a predetermined date or time. So that is difficult to prove, and I think that's part of the issue why we're not seeing the convictions on the misdemeanor level. I don't know if that helps your answer or not, but again, this is just seeking to say to the people that are going 2 or 3 cars down Walnut Grove Road, a residential street, at 80, 90 miles an hour, that will not be tolerated, and we will lock you up if you do that. That is what this is trying to accomplish.
Mr. Chairman, I have no argument there because I've seen it on the expressway. You know, we travel back and forth on the highway and in the neighborhoods and on the expressway highway. I've seen a lot of it. Most of the time it's a single car or maybe 1 or 2 trailing, but most of the time it's a single car. I have something hopefully is going to address some of it, but it's frightening, it's scary. But we need to know how effective we are at every level. So, Mr. Chairman and sponsor, Mr. Representative, thank you for the bill.
Yes, sir. Thank you. Any other questions for the sponsor? Seeing none, we're voting to send House Bill 2814 on the full criminal. All those in favor say aye.
Aye.
Those opposed? Ayes prevail. If you wish to be recorded as a no, please see the clerk. Item number 15, jump with me to item 15, House Bill 2198 by Representative Mitchell.
Chair.
You recognize there's 2 amendments.
Yes, Mr. Chair. So my amendment would become the bill. So it may be a procedure situation that the other amendment, that if the committee takes it up, we may want to roll my amendment to the hill and take up the other amendment first. But I'd like to just give a basic understanding of what this bill is going to accomplish.
Well, hang on. Let's get you in the right spot here. Amendment Code 13960.
Yes.
I need a. There you go. Now you're ready.
Okay. So this situation is threats to schools, threats of mass violence to school. In the fall, I had a call, and all of a sudden I'm driving as fast as I can to my child's school. Get there, there's 2 police helicopters, there's about 200 police officers. and the SWAT team is about to go in. You know, no parent wants to see that outside their school. Thank goodness it was a false alarm, but in today's times, they have to respond. If they don't, it's going to be a tragedy. As I was leaving that day with my son, I get a call from the speaker, and he said, this is an issue we can work on together. And I appreciate the speaker calling me and saying that. He said, you know that if they identify the person who made this threat, nothing's going to happen to them. And that came to fruition a few months later when a threat was called in to a high school in Crossville, Tennessee, in the speaker's district. They found out who made the call. It was a former student who now lives in Virginia. The sheriff of that county went to that person and reported back, well, they said they wouldn't do it again. And that was the end of it. You know, I'm sorry, you know, punishment may not always be the answer, but my child goes to a school named Martin Luther King High School. You would not imagine how many times he's been in a storage closet since 7th grade. I'm tired of people calling in, and this is aimed primarily at adults. You know, we've got some advocates who are concerned, you know, and that's where my amendment came in first. There's no intention of this bill putting a child with developmental or intellectual disabilities in jail for something they didn't mean to do, that their disability was a cause of that action. This is primarily aimed at the racist that wants to call Martin Luther King High School, or somebody else who just wants to call any high school and cause a problem and scare kids in today's society. They need to sit in prison for a year thinking about the next time they want to play with their cell phone. So with that being said, I'm at the mercy of the committee. My amendment, I committed to my co-sponsors of my amendment, but if the committee would like to take up the other amendment, I'm fine with that as well. But I'm going to keep my word to my co-sponsors of the amendment I agree to.
All right, any questions for the sponsor on the amendment? Seeing none, we're voting to adopt amendment code. Whoa.
I want to ask some questions.
Yes, sir, go ahead.
Obviously, your bill, what's your preference? Yours or the next?
My preference is to correct the situation.
I mean, with the amendment.
But it's not my intent to prosecute any child that has a disability that they didn't know what they were doing with making that threat. You know, some kid that's been bullied so much, you know, so, you know, with that being said, like I said, I made a commitment to my co-sponsors of the amendment they agreed to. They have not agreed to the other amendment, and I said I'm at the will of the committee on the other amendment.
Mr. Chairman, who has the other amendment? Okay, but, okay. All right, we'll hear. Thank you, both.
Thank you. Leader Lambert.
Move previous question.
Question's been called on the amendment. Any objection? Seeing none, we're voting to attach Amendment Code 13960 in the House Bill 2198. Those in favor say aye. Those opposed? Ayes prevail. You adopt the Second Amendment, Code 15095 by Chairman Halsey. Leader Lambert.
Well, Mr. Chairman, we've adopted the one amendment for the sponsor of the bill, correct?
That's correct.
And at this time, I make a motion for previous question.
All right, previous. All right, there's objection. We're voting on previous question. Those in favor of previous question on the bill as amended, say aye.
Aye.
Those opposed? No. The ayes prevail. We are now on House Bill 2198 as amended. Question on the bill as amended, Representative Johnson. You are correct. I'm thinking we were on the amendment still. We were on the bill. We adopted the amendment, then he called previous question. Previous question did prevail, so now we are voting on House Bill 2198 as amended. All those in favor say aye.
Aye.
Those opposed? The ayes prevail.
Thank you,
move
committee.
forward. All right, I'm going to hand the gavel off here to Representative Chairman Halsey. I need you. All right. I'm going to hand the gavel off to Leader Lamberth.
All right, members, we're back on item number 14, which is House Bill 2686 by Chairman Doggett. Chairman, well, excuse me, do we have a motion? Second? We have a motion and a second. Chairman, please explain your bill.
Thank you. I've got Amendment Code 15482.
Yes, sir. We have a motion and a second. Amendment Code 1015482. All in favor of adopting Amendment Code 015482 signify by saying aye.
Aye.
All opposed, nay. The ayes have it. It is adopted. Mr. Chairman, are we taking up Amendment number 1 or is Amendment 2 sufficient?
Amendment 2 is sufficient.
Thank you, sir. If you can explain your bill as amended.
Thank you very much. It's a clarification bill. In 2022, with the expungement work that was done, this one is coming back to help tidy those up and make sure that it is clear that you only get one expungement under sections G, K, or M. With that, I'm ready for any questions.
Outstanding. Any questions on this particular bill? All right, seeing none, we'll be voting on sending House Bill 2686 to full criminal justice. All in favor signify by saying aye.
Aye.
All opposed, nay. The ayes have it. All right, Mr. Chairman, your
All
bill
right.
is successful, goes to criminal justice full, and I'll pass the gavel back to you if you'd like.
Thank you
sir.
very much. Thank you. Go with me to item number 21. Item 21, House Bill 2417 by Representative Dixie.
Motion.
You are recognized.
Thank you, Mr. Chairman. TCA 402115 disqualifies anyone with a felony conviction serving as a fiduciary. TCA 402901 gives Tennessee citizens the opportunity to restore their citizenship rights. It also breaks down a restoration of citizenship rights into 3 separate divisions: felony conviction before 1986, felony conviction between 1986 and 1996, and a felony conviction after 1996. The process and procedure for the restoration of citizen rights for one convicted of a felony before 1986 is clear. File a petition with the circuit court with adequate evidentiary support and notice to the district attorney. Schedule a hearing and request the court to restore those rights. The process and procedure for the restoration of citizens' rights for one convicted of a felony after 1996 is essentially the same, except for with a few more steps. The process and procedure for restoring citizenship rights for a felony conviction between 1986 and 1996 is unclear. Under the statute, the process is for someone convicted between those years to request a form from the pardoning authority or the agent or officer of the incarcerating authority to be sent to the coordinator of elections, who will verify the form and issue a voter registration card. No circuit court petition, no notice to the attorney general. So it appears that only voting rights will be restored, as the General Assembly, for whatever reason, has not elected to provide the same restoration rights or opportunities for someone convicted between 1986 and 1996. I truly believe that maybe this is just an omission and that should be corrected. This bill presented would institute the process and procedure already in place for those convicted after 1996 and those convicted prior to 1986. So that's my explanation of the bill, but I do have someone, I know we're running short of time, so I'd like to get them up if we can and go out of session and listen to them.
All right. We've got about 3 minutes left of committee, so I'm going to give them 2 minutes to speak. We're going to go out of session, hear from Woods Drinkwater. Hello. If you will, introduce yourself for the record. You'll have 2 minutes.
I'll do it as quick as I can. Thank you, Mr. Chairman, members of the committee. My name is Woods Drinkwater. I'm an attorney here in Nashville. My pro bono practice consists of participating in the Tennessee Guardianship and Conservatorship Project. I take on conservatorships for low-income individuals. Conservatorships, for those who don't know, are a legal designation that takes rights away from someone who doesn't have the capacity to make certain decisions, such as medical decisions, end-of-life decisions, the ability to enter a contract, something like that. Takes those rights away from someone without capacity and entrusts those rights and decisions to someone else that will act on their behalf. Conservators are frequently family members, someone who's entrusted to make decisions in good faith on behalf of the ward. I have a 62-year-old client that lives here in Nashville that has been the primary guardian of her 19-year-old granddaughter for 18 years. Her granddaughter has severe Down syndrome. The girl's mother and father are not in the picture, and my client wants nothing more than to petition the court for to be appointed conservator over her granddaughter. But my client was convicted of a felony in 1989. The way the bill currently, or the way the statute currently is, she is unable to be afforded relief of restoration of her citizenship rights. I believe that it was an omission of the General Assembly not to give those rights to someone convicted between 86 and 96. I'm not sure why, but a court reading the statute as a whole would say this General Assembly means what it says, and it had the opportunity to afford these rights to someone convicted between 86 and 96, and for whatever reason, it chose not to do so. I've consulted with legal aid groups and pro bono counsel across the state to ask them, what do you do in a situation where someone's convicted of a felony between 86 and 96 to restore their rights? And the resounding answer is, we have no idea. The statute's not clear and no court will allow it. And if you give me 30 seconds, Mr. Chairman.
Man, you got 30 seconds.
Thank you very much. We have contacted the agent or officer of the incarcerating authority, the person who's supposed to supply a form to the Register of Elections. They don't know what the form is. They don't know what we're talking about. So what we're asking you to do is approve the bill as presented, present and give the opportunity of Tennessee citizens that have been convicted of a felony between 86 and 96 the same rights that are afforded to those that were convicted of a felony between 86 and after 96, and allow my client to provide the care of her granddaughter that she so deserves. Thank you very much, Mr. Chairman, the members of the committee.
Yes, sir. Thank you. And I know we're out of time, but members, if you do have questions for Mr. Drinkwater, you can get with Representative Dixie, and he'll make sure you get that contact information. You can reach out to him. All right, we're going to go back into session. We're going to roll this bill and all remaining bills that were not heard today to the next regular calendar. We are adjourned.